Good afternoon, everyone. I'm Alexis, Director of Statewide Training at Florida Legal Services, and I'm really excited to have you all here today to talk about elder law and estate planning. I know this is a subject that, a lot of you folks in the legal aid world, touch on or work with, and I know that, the population of our elderly folks and folks, especially our elder law clients that are part of legal aid, really have niche needs. It's not just the same as any estate planning case. It's not just the same as any, typical probate case. So I'm really excited that you all joined us here today and that you're going to get the knowledge to move forward in successfully representing your elder law clients through the processes of probate and estate planning. And before we get started getting into the content, I do want to give you some housekeeping announcements. First and foremost, this was approved for CLE credit. As you know, I love to get you all your CLE credits. At the end of the presentation, I will announce that CLE code. I'll also drop it into the chat. But for those of you who have been with me through these trainings before, you can email me for absolutely anything you need. For anyone new, no, you can email me for anything that you need. So if you miss the CLE code or you don't see it in the chat, don't worry, I'm going to put my email address into the chat and you can reach out to me directly to receive anything that you need, including that CLE code. Additionally, on that note, this is being recorded, and a copy of that recording will go out to all of you who are here present and those who registered but may not have been able to make it live. And that email will come from Zoom within 24 hours after this event. With that recording will be the CLE code. But like I said, if you miss it, you can reach out to me. And if you don't see that email from Zoom in your inbox, because we know, they often go to the spam box or gets overlooked, again, you can email me directly and I will make sure that you get a copy of this recording. That way you can go back, replay it, especially when that case drops into your lap and you're like, wow, whoa, I actually need to do this stuff now. Final piece of housekeeping announcements, questions and answers. We love to hear from you. We are in the webinar vortex, so folks are not really going to be able to come off camera and ask those questions out loud, but I will be monitoring the chat and the Q&A. Don't be shy. We've got a fantastic speaker here today, someone who's really an expert in this type of work. So get your questions out there. Everybody else is probably sitting there thinking the same question that you have. So don't be shy. Please drop your questions into the Q&A or the chat, and I will make sure that we filter those and get them read out loud to our speaker. So enough of the boring stuff, going to move directly into introductions of who we have here today. And I'm very excited to introduce to you Genna LaPeer, who is a graduate of Thomas M. Cooley Law School and a licensed attorney in New York and Florida. Before becoming an elder law attorney, Genna worked as a special prosecutor for the 5th Judicial Circuit in Marion County. As an elder law attorney, Genna knows that her job is important because she is making sure our elders are protected, cared for, and have the next step of their lives planned out. Genna's practice areas include probate and trust administration, estate planning, elder law, Medicaid planning, special needs planning, and probate and trust litigation and exploitation litigation. Genna is a member of the Florida Bar, the New York Bar, the Elder Law section of the Florida Bar, the National Academy of Elder Law Attorneys, the Academy of Florida Elder Law Attorneys, and the 8th Judicial Circuit Bar Association. Genna, we are so thankful to have you here. We're really excited to learn from you. And before I turn it over, I want to say, I realize, folks, I didn't turn on the closed captioning. I know I promised those. So I am going to enable those captions now for anybody that might need that extra assistance. And if anybody, needs me to assist them with what we already explained, just reach out to me via chat or Q&A or my email, and I'll assist you with what we missed as far as closed captions go. But all right, Genna, thank you so much for being here. The floor is yours. We are very excited to learn from you today.
Thank you so much, Alexis, and thank you so much for reaching out to our firm and having me. It's really nice to be able to get invited to speak at these sorts of webinars and have the opportunity to engage with others, because we need other attorneys armed with this information about how to do effective estate planning and what that means and what is included and what is elder law. So So happy to be there and provide as much information as I can. Please, if there are questions, we'll try to leave a good amount of time at the end. This is a webinar format, and so I can't see or hear anybody. So love to hear any comments or questions in the chat. And hopefully I can accommodate as many questions as we can get to. So let's start. We've got a timed agenda that's shared on the screen, so I'm going to try to stick to it as best I can. So the first place that we need to, so actually, let me just back up for a second. So our firm, the Miller Elder Law Firm, is not just estate planning, we're elder law. So it is more broad, and we'll get into that, than just estate planning. So the way that I look, or that we approach estate planning, is probably a little bit different than somebody transacting purely for a will or a trust. It's a little bit bigger than that. So on the first bullet point here about what we need to speak on, what is estate planning? Why do you need it? So in terms of what is estate planning, in my mind, when a client comes to us and they said, I need the comment is always, I need to get my affairs in order. I want to make sure everything is streamlined for my beneficiaries. I want to make sure everything is dealt with. So oftentimes they come to us thinking, okay, I need to get a will or I need to get a trust. And that is, certainly part of the discussion. And that first part of that discussion centers around, in my mind, understanding the lay of the land. Who am I talking to? Are they married? Are they widowed? Are they divorced? Do they have any children? Where do their children live? So understanding the dynamics. Are there any conflicts? Are there any special needs that we need to be addressing or planning for? How old are all of the parties? And then also, obviously, the asset component. How much? What are they? Where are they? And also, what are the assets in conjunction to how old the clients are? Like, what does the rest of their life look like? And obviously, nobody has a crystal ball, and they certainly don't have everything planned out. But, if I'm talking to somebody who is 80, and they need to figure out, okay, do I need a will or do I need a trust? And they've got, let's say, $1 million in assets, they could, depending on other factors, they might be well suited for a will-based plan. But if I'm talking to somebody at 50 who's still working and they have an estate of $1 million, a will-based plan may not be an appropriate fit because their assets are going to continue to grow. Their income and earning potential may be growing. And also within, the next, let's say 40 or 50 years, our estate tax limit may also decrease we know that it's going to be decreasing from $12 million to probably about $6 million. We don't have a final number on that, but these are all factors. So what is estate planning and why do you need it? Really, in my mind, begins with understanding all of the facts. So who are we dealing with? What is their family structure? If you can dive into the dynamic loosely, obviously that's a loaded question, but understanding, are there any conflicts amongst family members? Is anybody in a rocky relationship? Because if that's the case, then maybe we do need to have a trust, and maybe we need to have special provisions in that trust. Do we have children who either have, addiction issues or are just flatly bad with money? And so we're not going to give them an outright distribution of $1 million because that's not in their best interest. Obviously, you have to counsel your clients. You can't protect for every eventuality from the grave, but, we try to understand exactly how they're situated and plan at best as we can at that moment. Advise them that every 3 to 5 years, they really need to be looking at their estate plan and reviewing it to make sure it is still in line with their wishes. And then we also have to keep in mind that there is a whole secondary component. And that's, I think, sometimes where our clients say, I need a will. And I'm like, well, that's great. let's talk about it. But I also want to ensure that they are protected during their lifetime. So, against exploitation, that they have planned for in the event of incapacity or hospitalization or needing to be in a skilled nursing facility or assisted living. And basically avoiding at all costs, where we can, the need for a guardianship. So in my mind, the estate plan, like I said, is understanding the set of circumstances and how we're going to leave stuff at death, but also equally, if not more important, frankly, is how do we plan for their lifetime? Unfortunately for us, and I'll get into it a little bit more later, we do a lot of exploitation litigation. So the protection of assets during life, and arming and empowering our trusted helpers with the ability to step in and help when necessary is so incredibly important. Unfortunately, we see daily how somebody can have an estate plan, and if we don't have a really good durable power of attorney or similar document that gives somebody the authority to step in, we're going to end up having to put that person who has a trust-based plan in an emergency temporary guardianship situation because they just got exploited for $7 million and nobody was able to actually help. So let's talk about then, as we move forward here, what sorts of documents we're talking about. So this is, what is an estate plan and where can we go and what are the circumstances? It's very, let's funnel it down a little bit to the specifics. So what are we talking about? Will versus trust. Let's start there. For me, an assessment of which one is going to be needed. And there's several documents that we that we draft, depending on which way we go. So if it's a will, that one's our simplest model. So literally just a last will and testament, things that we like to include in there, obviously, where do you want your stuff to go when you die? Yes. But also we put in there, what do you want to happen to your body once you die? Do you want to be buried? Do you want to be cremated? Do you have a prepaid burial plot that we need to include planning for, or at least reference to? And the one thing that we always say is that, oftentimes people don't want to share their will or their, last wishes with their family members. That may be fine, but your family members or your trusted helpers, whoever's been appointed in your documents, needs to at least know where to find the documents. Because one thing that we know to be true is that the decision about what to do with somebody's body has to usually come before what are the assets and do we need a probate. So somebody may have wishes to not be cremated, but be buried, as an example, but somebody doesn't go look at their will until, 2-3 weeks later. So empowering your people to know where to go when you have good drafted documents, that's also very important. So a will is a will, and we can usually manage that when it's not a hard and fast rule. I generally say, if we're under $2 million in assets and the people, the clients are a little bit older and there's not crazy family dynamics or second marriages, I'm usually okay, or assets outside of the state of Florida, I'm usually okay with a will-based plan. A trust-based plan has the trust itself, but several other supporting documents. So let's also say this. In the state of Florida, joint trusts do not work well. On the back end administration of that, when we've got two people's social security numbers tied to one trust, the administration of that is very messy. So our practice, when we have a couple, because it's often a couple, come to us and say, we need a trust, or we determine that they need a trust. They say, we say to them, great, we are going to do separate trusts. They can have similar terms, but we are going to take your assets, put it on an asset list. We always have an asset list that includes What are the assets? How are they titled? The amount. We take that asset list after we've drafted the trust instrument and equalize the assets as best possible and divide them into the trusts. You try to do 50-50, but sometimes there are reasons that one trust may be funded more than another trust. So no joint trust, please. It's a nightmare. Separate trusts if we're doing a couple. Within our trust, we do have exploitation protections. We have mandatory prenup provisions. We have, I'm trying to think, some other bells. You also want incapacity provisions, right? So if a trustee becomes incapacitated, what is the process for kind of removing them and putting somebody else in there? That's very important. And so reasons why a trust, what you can do with a trust that you can't necessarily do with a will: hold money in trust, like I said, for problematic beneficiaries, like, an outright distribution of money isn't going to be good for them. If you've got property outside of the state of Florida, also likely going to want to look at a trust, because otherwise you're going to be stuck with a probate in Florida and then an ancillary probate in wherever other state that asset exists. And so we can avoid all of that by having one trust administration. Also, if they're second marriages, definitely want to trust. If beneficiaries are in shaky marriages where we don't where we want to protect our assets to make sure our kids get it and not, the spouse that they're going to divorce next year. So these are all, and also obviously large estates. That really hasn't been a driving factor for a lot of them, because we've been dealing with a $12 million estate tax limit. So for us, we know that that's going to come down. So now talking a little bit more about what the assets are, how much they are they spending down? Are they having more income? Are assets going to grow? Like, all of those discussions do end up factoring into, whether a trust is appropriate. Other documents that support the trust itself, we always have a pour over will. Why? Because most people forget the second step, frankly, to having a trust. So the way that we operate, we do the trust drafting. And I always say the trust drafting is like constructing the box, but the box that we give you is empty. So oftentimes people will retain us to do step 2, which is funding the trust, meaning putting things inside the box. We have a funding guideline manual that we give to all of our clients. So some clients end up saying, you know what, my assets are simple, or I think that I can make a good faith attempt to fund my trust according to your manual. And they're able to do that successfully. Other times people say, I'm going to try it according to these guidelines, but they end up coming back to us to say, things got a little more complicated. Can you step in? And also when we say funding a trust, what does that actually mean? It means titling assets in the name of the trust. An empty box is useless. We need the assets to actually have the trust name on it in order for them to be in the trust and therefore go through a trust administration. Other things so the supporting documents is that pour over will. So if we miss an asset, that should be titled in the name of the trust. The last will and the pour over last will and testament is this saucer to the teacup. So it ends up saying, yeah, you unfortunately end up triggering a probate possibly, but if you do have a probate, that saucer is going to say, or that last will and testament is going to say, whatever is in the residuary estate, whatever's going through probate estate is going to just be poured back into the trust, and then it would be funneled through the trust administration according to the trust terms as we originally intended. So really don't want to have to use a pour over will, but it's there in the event that, worst case scenarios. Other documents include, let me just make sure I'm on time here. Not so bad. Bill of sale. So we say that things that you cannot title. So jewelry, watches, antiques, all that kind of stuff. So it says that all of your tangible personal property that we can't actually write a title on, that isn't specifically determined or written out on your tangible personal property memo, which is another document. The bill of sale says any tangible personal property that I own now or that I will acquire in the future is brought into the trust as well. Certification of trust is another document that we include. Obviously, a trust instrument is going to be, fairly lengthy, 30, 40 pages, possibly. And lugging a 30 or 40 page document to the bank can be cumbersome. And then the bank's going to say, what am I to do with this? I'm not reading 50 pages. So instead, the certification of trust is a option to bring like a 10-page document to whatever institution and say, this is how I need my assets titled. And basically it gives the most important information on that document. We also sometimes record a certification of trust if there's been a change in successor trustees, depending on the circumstances. What other documents are included? We also deeds. Deeds are part of the estate planning process and very important one. So the discussion is, do we utilize an enhanced life estate deed for mortgage-free properties in the state of Florida? So those properties are able to transfer on death to the named remainder beneficiary in the deed, basically with going to the property appraiser's office and presenting a death certificate outside of probate, outside of a trust administration. It's beautiful for Medicaid planning purposes. It's an awesome tool. But sometimes if we have really complicated trust terms, or we have a trust leaving a bunch of residuary money or what have you to a charity, then a charity probably does not want to inherit a property. They want to take the proceeds from the sale of the property. So in that case, even though this property may, be eligible to have an enhanced life estate deed, we are going to instead keep the property in the name of the trust. So it's going to be a deed to trust. And that way we'll put an article in the trust that directs the acting trustee to sell the property, and that those proceeds would then flow through the residuary estate and get just proceeds to the charity, and they don't have to deal with selling a home, cleaning it out, none of that. So deeds are a secondary component. Now, finally, whether you have a will or whether you have a trust, all of our lifetime documents are going to be inclusive within that plan. So a durable power of attorney, and a good one. Like, we're talking more than what you think you need. And a healthcare surrogate. So the healthcare surrogate is going to be obtaining medical information, records, and decision-making authority if the person does not have the capacity to do it. And then the third one is a living will. And a living will is not a do not resuscitate order. And it is a separate power or authority from the healthcare surrogate. The living will simply says, or specifically says, that if you're in a terminal, end stage, or vegetative state, that my wishes are pull the plug. Now, conversely, we also have clients who say, no. If I'm in one of those three stages, my express wishes are that all life-saving measures be taken. So very personal decision. We get a lot of discussion about what does it mean to be in an end stage? What does it mean to be terminal? What does it mean to be vegetative? And actually around the time of COVID, that was a huge discussion point because we had people on ventilators everywhere, but they were recovering. So people were saying, no, don't pull the plug if I'm, recovering. And our counsel is, we are not doctors. We are talking about circumstances where death is imminent or there is no hope of recovery. And then they say to us, well, what does that mean? And then we say, that's going to be up to your doctor, because we have no idea about what might happen in the future or what medical circumstances could arise. the do not resuscitate order, just side note, is something that has to be entered into between a patient and a doctor. It is not an estate planning document. Stay out of that. We deal in situations where we have a guardianship in place and we need to get court order or authority to have a do not resuscitate order, but that's separate. For your run-of-the-mill estate planning, don't get involved with the do not resuscitate order. Separate ball, like totally separate circumstances and what it operates as. Okay, what did I miss in terms of documents? So will or trust, under the trust, pour over will, bill of sale, tangible personal property memo, and then all of your life certification of trust, and then all of your lifetime documents for either one, durable power of attorney, healthcare surrogate, living will, and any deeds. We also include a pre-need consent against exploitation in any of our plans, just because what we find is that when we're doing this exploitation litigation, one of the ways if you don't have somebody who's an agent under a durable power of attorney or a guardian, and you just have like a concerned family member, or there are no estate planning documents in place, which is often the case, the only way to get an exploitation injunction under 825-1035 is to have the consent of the vulnerable adult. And unfortunately, nobody wants to admit that they've fallen victim to a scam, or they've fallen victim to a scam and they're just not cognitively understanding what's going on. So they're going to fight you tooth and nail to get the consent so that to get this. So therefore, in a moment of clarity, just like a pre-need guardian or anything like that, we do the pre-consent and we say, should I be scammed, exploited, what have you? And these trusted helpers know about it. These trusted helpers have my consent to apply for an injunction to the court. So that's just kind of one thing that we throw in there. Okay, moving on, sort of on time here, not bad. How do elder law attorneys differ? And what is life care planning? Okay, so this is kind of where I started. It's a bigger picture. So we absolutely operate transactionally, and oftentimes estate planning is absolutely transactional. But your estate planning clients may come back to you for probate or trust administration. Like you'll see them again, as life goes on, as life happens, as circumstances change, marriages, babies, divorces, what have you. So what we found in our practice is that since we focus on all aspects of elder law, so not just the estate planning, but Medicaid planning, exploitation prevention, probates, guardianships, special needs. When we're looking at that, we ended up coming into a spot where there's one huge missing piece that often comes with these cases, and that is care. The question of what is the appropriate care, how to best get that care, and how to advocate for your care. So that actually brings us to the life care planning model. So, I'll be honest, personally, the warm and fuzzy, trying to be understanding of somebody's care needs or identifying, that's not my forte. Honestly, as a former prosecutor, there was a lot of that our victim advocates were able to step in and handle, because if you're dealing with the emotional side constantly, it's very draining. So this is really not my area or my forte. So Laura Monday is somebody on our staff that we term an elder care coordinator. And if you search life care planning, there is a national association of law firm, I think it's called LCPA, Life Care Planning Law Firms Association. It's a national association, and they have a program called, it's a certification for elder care coordinators. And that's the component on our staff that is different. So they're not an attorney. They're usually, they can come from different backgrounds, but they're geriatric care managers, social workers, nurses, But the role of this elder care coordinator in a life care planning model is twofold. Get the client the best care for the rest of their life, because these are one-year contracts that can renew at the option of the client. And so get the best care, but also advocate if they have a healthcare crisis. So if they fall and they're in a hospital and then they go to a rehab bed and that rehab facility is trying to kick them out prior to their Medicare guaranteed 100 days of coverage, our elder care coordinator is going to be like, get that discharge in writing. Also, why are they being discharged? And I will tell you, the answer is almost always, well, they're not improving. The therapy is not helping this person. So, it's time for them to go home. But that is not the standard. The standard is the therapy causing a decline, which is a very different assessment. So usually Laura hears this, we get a discharge in writing, then we appeal it. And I will tell you that the appeals are very successful. But she's also going to be that individual, whether it's our elder care coordinator or another elder care coordinator in this life care planning model, they're going to be the squeaky wheel for the family. This model really operates well, especially when we've got families all over the place. We've got a lot of snowbirds in Florida, and we've got children or family members in other parts of the country. And they're saying, how do I even know that mom or dad or grandma or grandpa or my aunt or my uncle is going to the right facility? I have no idea. I live in Washington. And then, so they come to us, and Laura, our elder care coordinator, Laura, would be the one to help be the boots on the ground for that family member, to basically say and guide them with the decision-making process. On the legal side, it's really a treat, frankly, to be able to be proactive with a family. So 9 times out of 10 we're fighting fires. They've been exploited. They're incapacitated and have no estate planning. We've got, they're going out of the country and they have no documents. Let's draft some documents real quick. And we can never really get ahead of what's happening. So with Laura taking the care section, we would, let's make an assessment. Where are these clients at today? They're capacitated, they're living at home, they're independent. Wonderful. Let's get them a trust-based plan. Let's get their documents in place. Great. Set them up. Get all of their estate planning done. Have their assets titled correctly. But let's just hypothetically say that there's a decline. Something happens in month 11 of a life care planning model contract. Then we are going to say, okay, Laura says we need to put this person, they need more care. They need to be in a facility. So we're going to undo all of that beautiful estate planning we did in month 2, and we're going to move into asset protection or Medicaid planning, and then I will also say, they don't, pay anything more for that. So it's the ability for us to have continuous oversight and continuous care and continuous advocacy for our families. So that's the biggest difference between elder law and simple estate planning, and even elder law and life care planning. So anyways, that's probably been a part of our practice for the last 3 years. And it's just nice to not have to be fighting fires constantly. Obviously, those fires exist and we can step in, but to do a little bit of proactive planning is really, really nice. So segue into the last kind of component here, asset protection, exploitation and Medicaid planning. So we talked a little bit already about exploitation, that pre-need consent against exploitation. The Ulysses clause is what we call it in our trust-based plans. We also have something called Careful. It's an app, the Careful app. There are a company out of California. They don't pay us anything. We just think that their app is useful. And we offer it to our clients if it's appropriate. What it does is it monitors the accounts of a loved one by the trusted individuals, and alerts get sent to that trusted individual. So if there's weird transactions happening, people are busy, so they're not going to be monitoring. They don't have the ability to monitor somebody else, mom and dad's accounts, 24 hours a day, 7 days a week. They're going to try to do their best and they're going to check in. But this Careful app plugs in all their information. If there's weird transactions or over a certain dollar amount transactions, then it pops a notification to the trusted helpers, who then get, prompted to look into this further. So anyways, Careful, it's a good exploitation prevention tool for clients. So Medicaid planning, like this is, we could probably be here until next week talking about Medicaid planning, but the biggest, misconception is I'm over the asset limit, I won't qualify for Medicaid, and or I know that I'm over the asset limit, so I'm going to give away all my money to my kids because I don't need that money. I want them to have it now, and then I'll qualify for Medicaid. Both untrue. So in Florida, we're very fortunate. We do not have to use these. A lot of other states have to use something called 5-year trusts, and they have to do them years in advance in order to prep for a Medicaid application. We don't have to do that here. I will say that depending on your state, or excuse me, your county and where you are within the state of Florida, I do know that Medicaid applications and the experience through that process is different. We are very fortunate in North Central Florida that our Medicaid applications, with our planning, knock on wood, goes very smoothly. I know that that's not necessarily true everywhere. But so what are we talking about? So when we're doing a Medicaid plan, the asset information is of critical importance. If you don't have a good asset list, meaning again, what the asset is, how it is titled, very, very, very important, and the amount, then you really can't effectively do the planning. We also say that we don't want to do the planning 6 months out. We probably want to do the Medicaid planning and asset assessment more like probably more of a situation of like 4 to 6 weeks out from the time that we know that somebody's going to enter a bed. Because one of the what requirements to apply for Medicaid is what we like to say is a butt in a bed. If you don't have a butt in a bed, you're not making that application. So if you think, oh, I'm going to go to, the Ayers in Trenton in 6 months from now, we're going to say, okay, well then, we'll see you in maybe 5 months from now, or even 6 months from now, because so long as you've got somebody in a bed, a Medicaid bed in a facility, we're able to backdate the application status. So we try to do applications, by the 30th or 31st day of a month. So long as that application is submitted, and you technically go Medicaid pending at that point, Medicaid will kick in from the beginning of the month. So we don't have to worry about planning 6 months out. It's not even effective because the assets can drastically change by the time we get to butt in a bed situation. We have to look very closely at, I'm just doing a time check here. Okay, we're good. Do we have homestead? Is it a couple that is applying? Do both spouses need Medicaid at the same time? Or do we have a well spouse? And therefore it's an entirely different assessment. The amounts change yearly. So before you're going to jump into Medicaid planning, definitely make sure you're up to speed on what the dollar amounts, the exempt dollar amounts are at that moment in time that you're doing that planning. And then the thing is, if the community spouse, so one spouse is the sick spouse trying to apply for Medicaid, the secondary spouse is going to stay home and they are well for the moment, They can have up to, like, I think it's this year, $149,000 of assets. But if they need more money than that, then we're going to have to do a whole other application for spousal support for them to get more money and to live comfortably. So Medicaid planning is very, it's an art to a certain extent. So what are you presented with? And then how can we utilize the legally exempt assets pursuant to how Medicaid operates? So homestead is exempt up to a certain dollar amount. I think it's like 260 something. Don't quote me on that, but I can get you guys the most recent figures. So homestead is exempt up to a certain amount. Tip there, if it's mortgage free, we absolutely want to title that homestead in an enhanced life estate deed if we are doing a Medicaid application, because for two reasons. One, it is not a disqualifying event for the purposes of Medicaid because the transfer does not happen until the person dies. And two, when the person dies, Medicaid's not going to take the home asset because the title has already sprung to the remainder beneficiaries. So super important that if you've got a homestead and you're going to keep it as part of the plan and it's mortgage free, make sure that's going to be in an enhanced life estate deed. Other things to bear in mind are going to be retirement assets. If you haven't taken an early distribution, those are exempt. Funeral, burial, prepaid plans, those are exempt. We've got a lot of different tools that we can also use. For example, if we've got other property, or we've got just a surplus of money that we're trying to put somewhere, we could do rental income producing property. Rental income producing property isn't just necessarily you saying, I need to go buy property and property manage it and find tenants and all of that. That is an option. But oftentimes we up here use something called Epic. They're an LLC out of Ocala, Florida, and they take the money and they invest it into their rentals, and they kind of do all the management of that. Another tool is a single payer annuity. So we take money out of, got to liquidate our CDs, for example, put it into the single payer annuity, which pays the person back over 24 months. So, you know, you kind of have to do a bit of an assessment there. If you're dealing with a well spouse, that may be absolutely no issue. But if that well spouse is liable to have some health issues in 2 years, you're not going to get that full amount back. So basically the assessment is, without a crystal ball, will this person live 2 years in order to see the full realization of their payment back in 24 months? So all to say, we don't have to use 5-year trusts. We're trying to do Medicaid planning as close in time to when we get somebody in a facility as possible. We are subject to a 5-year look back period. So we don't need a 5-year trust, but we are still subject to a 5-year look back period, meaning that don't start gifting all this money away within that 5 years, because we're going to have to explain it to Medicaid. That's another counsel to our clients who may need it in the future. One other tool that we use actually two other tools that we use often, and then I will wrap it up for questions. A personal services contract. So if we have family members providing services, we can typically say, okay, at $15 an hour, you provide roughly 20 hours of care for the week, whether it's running errands, paying bills, upkeeping the house, what have you. And we can shelter some assets according to that calculation. And then finally is going to be the income. So assets are one assessment, but income is another. So basically anything over $2,000 for a single person is going to be problematic. And for that, we typically use a qualified income trust, sometimes a pool trust. But the key there is to not overfund those trusts, because Medicaid will take back whatever is there. And then the overarching goal with Medicaid planning is to plan so that we don't have to trigger a probate, because Medicaid is going to be a creditor there. So again, it's Medicaid planning and asset protection, but you know, it's certainly what are part of being an elder law attorney and how it goes beyond basic estate planning. So anyways, with that, Alexis, if you want to help me field some questions here, that would be great.
Yeah, sure. Thank you so much, Jenna. That was extremely helpful. Really appreciate the practical knowledge, that you gave us on really how to navigate these things on a practical level. A few questions did come into the chat. I'm just going to read them in order. And actually, before I go through the questions, I do want to just pop the CLE code into the chat in case there are folks that, don't want to stick around for questions. Very quickly, that CLE code is 2309229, N as in Nancy. Again, that's 2309229, N as in Nancy, 1 general CLE credits. So I'm going to pop up to the top. Oh, I think we even had some questions in the Q&A. There were a lot of questions. I only saw the ones in the chat. Where to begin? I will start on the chat where it says, can more than one representative be named to a will/trust? So I don't know if they mean or trust, will or trust, or a pour over. I don't know exactly the distinction there. So can more than one representative be named to a will/trust, or does that create a problem?
If we're talking about, two different terminology. If we're talking about a will, yes, it's going to be a personal representative. Yes, you can have more than one. Again, understand your client, because if you've got people fighting, you probably don't want to appoint them as co-PRs. So yes, you can do co-agents. You definitely want to vet that dynamic. We probably err on the side of having one and then a couple of backups. So one at a time, but definitely having backup people. With a trust, you would not have a personal representative because it's not a probate. It's a trust administration. So you would have successor trustees. And that is also an exercise in understanding your client's dynamics, because I will tell you that sometimes when we've got clients on the verge of incapacity, we don't even make them a trustee of their trust. They say, I don't want to manage my assets right now. They are mine, but I'm going to appoint a trustee right now. So I'm going to be grantor and I'm going to assign my trustee duties to somebody else. We can do co-trustees. And then at a minimum, we're definitely you want backup people on all your stuff. That's when you don't have to redraft them, because like somebody dies or somebody moves or what have you. So anyways, just an exercise in terminology too.
Yeah, absolutely. Second question, can a person do an enhanced life estate deed on both a homestead property and a rental property?
Yes, any property in Florida that you own that is mortgage free, homestead or not.
All right. If there is a husband and wife with tenants by the entireties, and one needs to go into a facility, do we need to create a life estate deed?
Sorry, say the beginning part again. It cut out on me.
No, it's okay. If there is a husband and wife with tenants by the entireties, and one needs to go into a facility, do we need to create a life estate deed?
If you can, absolutely, I would try. I would say the way that you would want it titled, if it's mortgage free and you're going to go on Medicaid, what you don't want to trigger is a disqualifying event for Medicaid. So you want to leave it husband and wife as owners. You don't want to transfer property out of their name. We just want to ensure that we can get the remainder beneficiaries on there.
Got it. And last question that came in through the chat, but folks, you can feel free, to keep asking questions, and then I'll hop over to the Q&A and I'll check the chat back again. But the last question I have here in the chat is, what is the best way for clients to store their will and other estate planning documents? Is a safety deposit box a good idea?
No, hard no. Because what happens, and if there's a will and a safety deposit box and nobody has access to it, because we don't want to have assets tied, like parents often want to add all of their kids to all of their accounts, which is also a terrible idea. So if they are properly titling their stuff so that they're the only ones with access to their safety deposit box, then we need to get an order from the court opening the safety deposit box to get the will. Much more complicated. The letter that goes out to our clients, once we give them their nice estate planning package with a bow, is store it in a waterproof, fireproof box somewhere in your home, and tell somebody, like your personal representative or your successor trustee, where that is. That's kind of the fastest, easiest way to do it.
Got it. All right, turning to the Q&A. Why is a trust recommended for second marriages?
Simply because you don't necessarily want, if you've got kids from another marriage, or you've got, depending on the status of that second marriage, you don't want your assets intermingled. So what we often see is like mixed second marriages. So one spouse has kids from one marriage and the other spouse has kids from another marriage. And, they may not necessarily want all kids getting the same stuff. So in a trust, we can better control and protect how we are going to funnel our assets. Because when we don't necessarily have children in common in a second marriage, it's not as certain that if something gets screwed up, that your kids are going to get your stuff. Because if the first spouse dies, and something's not titled correctly, the first spouse's kids are going to be SOL. Everything is going to be titled in the surviving spouse's name and then go to the surviving spouse's children. So if you die first, your heirs could possibly be out of the picture. So in a trust, we can just craft it and draft it and ensure, because we're not going to go through a probate, that our beneficiaries are in fact the ones that are going to inherit.
Got it. Next question. I like the humor in this one. For those of us who know nothing about this subject matter, can you please explain the $12 million tax?
So at the
tax cap, or whether you're saying yes.
So basically, if your assets, your estate, when you die, if you've got more than $12 million in the bank or in real estate or what have you, don't ask me what the tax rate is on it, but your estate will pay a certain percentage of taxes due to the size of it. So right now, I would say the average person loosely is under that. So it's not a huge issue. But when we start seeing a limit coming down to 6 or 5 or 4, then more people are going to be subject to taxes. If we put it in a trust, we can shelter an estate from paying those taxes. Again, this is all about preserving assets and ensuring your beneficiaries get the most out of it.
Okay, and then the final question I have here, and then I actually wrote a couple down that I might bother you with, is, are personal needs contracts routinely challenged by Medicaid? You mentioned, an example of 15 an hour. Is that a common rate that's paid?
Yes, and that's why I said it. So they can absolutely be challenged. We err absolutely on the side of conservative planning. $15 an hour, 20 hours a week is usually, knock on wood, has been a safe bet. And, it can be for more than one caregiver. So you can do that contract if there's, like I just had one and there was 5 children and they were all helping mom and what have you. Like, we're not going to do 5 personal services contracts, but we can probably pick, the 2 people most involved and give, they truly were providing her round the clock care. They were staying overnight. They were doing all her groceries. They were showering, like all of the things. She's really, that is the reason she's really set for a bed. But yeah, so we picked 2 of the 5 and did contracts for 20. I think we might have actually done 17 and a half hours a week at $15 an hour. So sometimes, like, depending on what the whole picture looks like, err on the side of being conservative. Definitely, if you're going to do $25 an hour, I don't know about that.
All right. So just going back to some questions I asked, I hope this is helpful for people. This is a subject that I'm not as familiar with, so I apologize if it's not. Something that often comes up in conversations that I have with, legal aid advocates is exploitation, elder, exploitation. And you mentioned, I believe it was specific in trusts, about specific exploitation protections that you embed into the trust document. Can you elaborate just a little bit on that? Like, is it just language that you use? Is it?
It's a clause or an article, and it says that, and again, this is all in consultation with your client, like how much money they have, what is an exceptional transaction for them. Like if they're, doing international business, $100,000 transaction, may be okay. So it's, again, it's understanding how your client is situated, but basically we put in dollar amounts in there, and it's not a trustee, it's a third party that ends up coming in to say, if we see these transaction amounts, we can lock it down in the trust. So when I was talking about pre-need consents against exploitation, we're talking about applications to the court under 825.1035 to freeze assets. But the Ulysses clause within a trust just allow the trustees to close down assets in the trust, so we don't have to get a court involved. Helpful.
Yeah, very much so. I'll forego my questions because another one came in through the chat. What would be the best move for a married couple where both are 65 and have a lot with a newly built home, which will soon be their homestead? They both want to retire in the next 2 years. Thank you. So what would be the best move for a married couple that are 65 and have a newly built home and it'll be their homestead soon?
In terms of, I guess, like estate planning?
I would. I don't know if they have in the question. I don't know if they have children. I don't know. That's
Right.
sort of additional facts that might be helpful.
I think to answer it, we would need additional facts. So I would want to know, how much they have, what is their income, do they have investments that can grow, are they planning on ever purchasing property outside of the state of Florida, are their kids minors? So a situation that I just had, it might have been yesterday, I think they might have even been 60, and one was retired, one was not, and they had, I think, about 3.5, actually, no, it was like $2 million in assets. And they had minor children. And they told me that they were going to be purchasing property in North Carolina. So like at face value, with $2 million estate, no real issues with the kids. They probably could have been fine in a will-based plan, but we ended up actually choosing to do a trust-based plan because they didn't want to come back and redo stuff. They just, they may do trust amendments, but to redraft the estate plan, they didn't want to do that. So they told me that their assets would continue to grow. The working spouse was earning like, I don't know, $300,000 a year. And then his investments were going to grow. And then they got this other state property. And then they wanted guardians for their minor kids. So for all of those reasons, the State of the Union today might have been fine for a trust, but like even in 2 years from now, they wanted room to grow in their estate plan. So I would ask a few more questions on that one.
Got it. All right. And we're rounding that 1 o'clock, time frame. So, I think out of the questions that I wrote down, the only other thing I was going to ask is, I know you mentioned that your firm has, a trust manual that, you provide people that, let's say you're retained, just to create the box. I like that analogy. I know, and to maybe put their own assets into the box. And I know as legal aid advocates, we're always looking for, resources that I'm sure is like, work product of some respect. But do you have any I was thinking like any resources like that, like any manuals like that legal aid might be able to look at if it's online, if it's something that you know of from a different firm or something like that, or a different resource. And then I was even thinking like sample intake questions. Like, I don't know if there's any sort of, they're just like some questions that you might not think to ask. And it'd be really great to just have a document that, especially our young lawyers, we get, some young legal aid lawyers that, really want a script, especially in the beginning. So if you have anything like that and you're willing and able to share it, I think that we would all really appreciate it.
Leave that with me. I will get back to you on that. I know that there is something that we can provide. I may just have to redact a couple like client things, related things, but we can certainly get something for you guys. Cause for me personally, I was 100%, green when it came to the world of estate planning and elder law coming from the criminal world. I completely understand, coming into that and just needing a little bit of guidance or a couple of tools to just, help get started or, just get additional information. So I'll deliver, just leave it with me.
All right. Well, I appreciate that very much, Jenna. And I will say some folks in the chat have said, thank you. This was a phenomenal opportunity. Thank you for sharing your time with us. Thank you for all that you do, because even though we do it on the legal aid side, I think all together, the common denominator is really caring about our elderly population. And so thank you for all that you do. Thank you to all my legal aid folks who have joined us here today and are out there on the front lines doing the work that you do. And if there's anything else that you want to say, Genna, before I let you go.
No, I'm good. Thank you all. I really do appreciate the invitation to speak to you, and hopefully we can do it again.
Awesome. All right, Genna. Well, everyone have a wonderful rest of your week, and we'll see you next time.
All right.
Bye.